Good day, everyone. Today we're going to discuss a new lesson for media and information literacy. Welcome again to our class. But before that, let's have a quick review of what we have discussed last meeting. Last meeting, we discussed a current events issue, and that is the ABS-CBN renewal of franchise issue, for which we've been able to identify some of might be reasons why ABS-CBN is still not getting its renewal of franchise. And also, we've looked at some of the grounds that the government is citing why they are not renewing yet the franchise of ABS-CBN. But we've also come to know that many of the grounds that the government cited were cleared, or the ABS-CBN were cleared of these grounds, meaning they did not violate these laws that being cited, for which people from the government said that they violated. So just to have a quick review, no, let's look at this particular sentence. All rights and freedom vested to us by the government is not absolute, meaning everything should still be subjected to rules and laws so that no one would abuse these rights, and including the Philippine press freedom, or the freedom of the press. It's included with the rights and freedom bestowed by the government. Now, if the government sees that people from the media are abusing these rights, then they also have the right, looking at these laws or citing these laws, they have the right to reprimand, or they have the right to penalize people who are abusing these rights, or they have the right to uh, file a case, or they have a right to, in the case of ABS-CBN, not renew the franchise of the company if they see any irregularities, if they see that these companies or these people are abusing these rights. Okay, but the big question right now is, did ABS-CBN really abuse their rights? Or does the government really have grounds for which they could say that the ABS-CBN abused the right of the media? So that is the question that still being posed to us. No, and I believe you already have your opinions regarding that. But at least I believe that things have been clearer to you right now that we have discussed that particular issue. So now, let's go to another lesson. We're gonna talk about laws again, rights, okay? But this time we're gonna talk intellectual property rights. What do we need to know about the intellectual property code of the Philippines, or the IP code of the Philippines? So why do we need to have a knowledge of the intellectual property code of the Philippines, or the IP code of the country? Okay, I think you might have an answer also. If we're gonna answer is, it's simple, because you belonging in this ICT strand, or belonging to strands which would take up courses for which you will have to create original contents, you would have to create literary works, you would have to create contents for the digital age. For example, right now you are creating games, okay, or you might be writing literary things. You might be writing a book, you might be composing a song, you might be taking photography classes, and you're taking a lot of photograph. You might be very passionate about painting. So these are just some of the examples of intellectual properties, things that you originally made. Now, if you know the rights that you have with these creations of yours, then you'll know that you are protected from other people who would like to use your original works without any permission. Okay, so it's important for you to know that you have protection from the law. The government is giving you a protection by the virtue of this law so that you would be able to have rights on your own creations. But of course, this Intellectual Property Code of the Philippines is not just limited to that. They also cover a lot of things, which we will discuss soon. Also, why do we have to have a knowledge? Why do we need to have a knowledge of IP code? Because if you will create contents, especially if you're going to create contents for digital, or if you're going to go create contents for businesses, if you're going to start a business, then you create a lot of things, a lot of stuff. If you're going to invent things, you would have to make sure that you did not copy or you did not imitate someone's work, because you could be penalized for it. I mean, you could be uh, subjected to a particular consequence by the law for doing an imitation or a copy of someone else's work. So now you would have to properly cite, you would have to know about how to properly cite the creations of others, how to ask permissions from others, so that you will not use their works without their consent. Okay, because if you do, then there will be consequences. Like for example, if you plagiarize something, then there might be, or there are consequences. Right here in the school, we practice that if someone plagiarizes a work, then the teacher usually opt to give a 0 grade, no, for that student who committed plagiarism, or there could be worse consequences with that. So now, it's important for us to have a knowledge that the original works of others are protected so that other people will not use it and claim these works as their works and later on receive the consequences for doing so. So first, let's define intellectual property or IP. Intellectual property refers to anything created by someone, including but not limited to inventions, literary works. Later on, we're gonna discuss further what are some of the other examples for these. So also included with IPs are items created by artists, symbols, designs, images, pictures, and even names that are used for commercial purposes. So these are all the things which are being covered by the so-called intellectual property or IP. So from the word itself, intellectual property, it means a creation which directly come from your intellect or your creative imagination or your knowledge that you put into work. Now, if we're going to look at a particular law which covers and protect people's intellectual property, and then we have Republic Act or RA 8293. It states that this is an act prescribing the Intellectual Property Code and establishing the Intellectual Property Office, providing for its powers and functions and for other purposes. Let's discuss what are the salient provisions of this particular law. Under the Intellectual Property Code of the Philippines or RA 8293, the term intellectual property rights consists of the following: copyright and related rights, trademarks and service marks, geographic indications, industrial designs, patents, layout designs, protection of undisclosed information. From these, we're going to discuss just 4 items. So let's go to the following intellectual property that is under the IP code of the Philippines. Number one, copyright. One of the, I think, most common, because I believe everyone from the time they were born until the time they graduated from high school, they've been able to create hundreds of original works. So your original work is under the copyright. So let's define further. Copyright is the legal protection extended to the owner of the rights in an original work. What is original work? Original work refers to every production in the literary, scientific, and artistic domain. So among the literary and artistic works enumerated in the IP code includes books. You might have written a book. You might have made comic books, or you might have written novel books and other writings. That could include your scientific writings. Also included with IP are musical works. You might have composed a lot of songs, or you might have created a new music, diba? So it's also included in the copyright. Films, I think you've made films already in your other subjects, or in your subjects during your junior high, so you have copyright for that. Paintings, many of you are painters or artists, and other works. Also included in the copyright are computer programs, something that the ICT strand is always working on. So furthermore, copyright laws grant authors, artists, and other creators automatic protection for their literary and artistic creations from the moment they create it. Let's give an emphasis to this. Automatic protection for their literary and artistic creations from the moment they create these works. Which means, even if you did not register your work to the Intellectual Property Office of the Philippines, you still have this automatic right, or this copyright for your creation. So if you painted something, then someone else used it, you could file a case for it, because someone else used it for commercial purposes, or someone else has owned your work. Someone else has said that your work is their work, so you could file a case regarding it. So if someone used your photograph, if someone used the game that you created, if someone used the song that you composed, then you could file a legal case for that, because you have a copyright for it. You have a copyright for it. Okay? So you don't need to even register it. So what's the purpose of taking your original works to registration? The purpose is you'll have I mean, if the purpose is, if i-register mo yung original works mo, then pwedeng magkaroon ka ng mas malaking hawak na kapag dinala mo sa korte at kinasuhan mo yung tao na sinasabing sa kanila daw yung gawa mo, then mas meron kang malaking hawak kasi it's even registered in the IPO. So it's on paper. Ibig sabihin, meron kang pinanghahawakang papel. Meron kang pinanghahawakang papel, legal papers, that those works are your own works or your own original works. So that's the advantage kung i-register mo yung gawa mo. But again, ulitin ko, I would just like to repeat it and give emphasis to this, that you have the copyright, or you have the automatic protection for your original works the moment you created them. So the moment na nagawa mo yung isang song composition, yung isang pelikula, yung isang computer program, yung isang app, automatically you have the copyright to it, because you did it. Given that it's not an imitation of something, given that it's really out of your own original idea, given that you did not imitate other works for doing it. Okay, then that's your original work and you have an automatic protection for that. So the right holders of a work can authorize or prohibit the production of these original works in all forms, including print form, sound recording, public performance, and communication to the public, broadcasting, translation into other languages, and adaptation, such as from a novel to a screenplay for a film. So now you have the right to stop anyone from redistributing your original work without your permission. You have the right to authorize, on the other hand, people who would like to use your work and who would like to earn money from it. So if you have an authorization, you have a permission for these people to use your works, then that's okay. But also you have the power to prohibit them. If you think na they're not using your original work for good, or they're just earning income for themselves out of your original work, then you can prohibit them. You can stop them from doing so. So you have that automatic protection, you have that automatic right. The term of protection for copyright in literary and artistic works and in derivative works is generally the lifetime of the author plus 50 years. Okay, so if the moment you started or the moment you created a particular original play, then that's the day that your copyright started also for that particular work. For example, nag-compose ka ng isang song. Tapos, natapos mo yung song na yon April this year. Then, yung song na yon may copyright starting April this year hanggang sa mamatay ka daw or hanggang sa mag-last yung life mo plus 50 more years. Okay, so, kung mawala tayo sa mundong to, wag naman, di ba? After 50 years, sabihin natin siguro mga 70 years old ka during that time, plus 50 years pa, so kumbaga 120 years yung copyright nung original work mo na yon. So hindi pwede siyang gamitin na kahit sino man nang wala yung permission mo. Hindi siya pwedeng pagkakitaan ng sino man na walang proper procedure for doing so. Okay? So, but different rules may apply, however. Works of joint authorship o yung mga original works na merong kakasamang iba na gumawa. Works of anonymous or pseudonym works o yung mga works na nagtatago sa mga pen name o kung ano pa man. Like for example, si Bob Ong, di ba? Marami siya mga sinulat ng mga books, ganyan. Medyo iba yung nag-a-apply na years of copyright na meron siya for it. Photographic works, your photos, the photos that you are taking and you are publishing, medyo iba rin yung years, okay, ng right na meron ka for it. Works of applied art and audiovisual works. But in general, the life or the term of protection for that copyright is your lifetime plus 50 more years. Okay, so ganun kahaba. Ganun kahaba yung term of protection that you have for your original work. So now, there might be some of you who would like to register your original work in the Intellectual Property Office. So what do you need to do? Number one, you need to fill out an application form from that office, attach a copy of your work, and then pay the basic filing fee. And then pay the basic filing fee of 625 pesos for every work, I think. Yeah. So medyo mahal siya, especially for you students. So ngayon, kung wala pa pa-register, at least, diba, under this law, granted na you already have your automatic protection, term of protection for that particular original work. Okay, next. So what happens if someone used your original work at pinagkakitaan nila yan for commercial purposes? Or what happens if gumamit ka ng gawa ng iba at hindi ka nagpaalam at pinagkakitaan mo yung gawa nila. So ito po yung mga magiging kaparusahan. Kapag napatunayan, first offender, ang bayad po ay 50,000 to 150,000 or imprisonment of 1 to 3 years. For second offenders, 150,000 to 550,000 fine and or imprisonment of 3 to 6 years. For third and subsequent offenders, fine of 500,000 to 1.5 million pesos and or imprisonment of 6 to 9 years. Okay, and makikita naman natin dito that mapaparusahan ka for doing so kapag gumamit ka ng gawa ng iba ng walang paalam o walang tamang prosesong sinusunod. Lalo na kung ginamit mo to for commercial purposes. Lalo na kung ginamit mo to para magkakitaan. So now I just wanna give you out some help. No? If there are images that you are using for the game that you are working on, or if there are images that you are using for the film that you are working on, or a documentary that you are working on, best way is for you to cite these images. So how would you be able to do that? You can check www.citationmachine.net. It's available in there how to cite images using different formats, because there are different formats that you could use to cite your sources. Okay, like for example, there's an APA style, there's an MLA style. So available on this particular website, the instructions or the way on how you would be able to properly cite the images of others that you will use for your work, especially if you're going to use it for educational purposes. Question, what if ginamit mo siya for educational purpose? Makakasuhan ka ba sa batas? At magpa-fine ka ba nitong mga pinapabayad dito? Answer is no. Okay? Because you use it for educational purposes. The least thing that could happen to you as a consequence for this is that your professor or teacher might not give you a grade for if you imitated someone else's work, or if you said that someone else's work is your own work. Okay? So under the law, you will not be filed with this infringement or copyright infringement. But I mean, under the school institution or the institution that you are in, they might be able to give consequences for what you did. Okay? So ingat-ingat po tayo. Let's always cite our sources. Let's give proper credit to the people who this credit are due. Okay? So let's give proper credits to other people's work. Okay, so are we clear with copyright? So makakasuhan ka kapag ginamit mo siya for commercial purposes. Yan, pwede ka talagang kasuhan yan. Okay, lalo na if you're on the legal age already, if you're 18 and above, then you will use other people's work so that you will earn money. Then someone could file a case of copyright infringement against you. Okay, so aside from copyright, under the IP code of the Philippines, it's also discussed there the so-called patent. What is a patent? Patent is a government issued grant. So unlike yung copyright na automatically when you created it, sa'yo na agad yung term of protection for it, or meron ka na agad na copyright, o meron ka na agad protection for your original work. Patent is government issued, meaning you would really have to apply and register this patent, okay, this invention patent, to Intellectual Property Office. Again, patent is a government issued grant, so you would really have to register your patent. Okay, it's really required for you to register your patent before you could pursue a patent infringement against someone else. So an invention patent is a government issued grant bestowing an exclusive right. So you would have an exclusive right. You would have exclusive right to an invention or to your invention. So this bestows this exclusive right to an inventor over a product or process that provides any technical solution to a problem in any field of human activity which is new. These are the requirements. If you're gonna apply for a patent, you have to make sure that your invention is new, it's inventive, it's industrially applicable. Ibig sabihin, bago siya. Ibig sabihin, meron siyang innovation na ginagawa, merong improvement on a particular product kang ginawa. So, pag sinabi nating patent, it could include a lot of things. It could include garments, it could include shoes and garments, it could include cars, it could include furnitures and appliances. Okay, like for example, nakapag-invent ka ng isang very innovative yung invention mo na nakapag-invento ka ng isang sapatos na lumilipad. O kaya kang ilipad. Diba? That's something new. Diba? Baka wala pa nakaka-invento talaga niyan. Then, you have to apply for a patent. Okay? Kasi if you don't, someone else might steal your idea or someone else might steal your invention, the idea for your invention, and then maunahan ka nilang i-register to for a patent. Then talo ka dun. Hindi ka naman naka-invento ka ng eyeglasses na kayang o merong eyeglasses na merong pamaypay. Weird. Okay. Or eyeglasses na nag-emit ng hangin. Ganyan. Kasi kadalasan ginagamit mo yung eyeglasses para pag mainit, di ba? So, eyeglasses na nag-emit ng air conditioner. Like, eyeglasses na kayang palamigin yung pakiramdam mo. Okay, then you would have to apply for a patent. Okay, so those are the things that you could do. Kunyari, naka-invento ka ng kotse na kayang patakbuhin sa pamamagitan ng tubig lang. As in, no oil needed, no gasoline needed, then you have to apply for a patent. Ano ba ba? Naka-invento ka ng bag na ang 5 kilo kaya niyang pagaanin. Kaya niyang gawing 2 kilo. Dahil doon sa pagkaka-structure, pagkakagawa mo ng bag. Diba? Then you would have to apply for a patent. So, a patent is an exclusive right that allows the inventor to exclude others from making, using, or selling the product of his invention during the life of the patent. So, by applying to a patent or by getting a patent na right, then, pag sinabi exclusive, ikaw lang yung may karapatan para pigilan ng iba na gamitin, na mag-recreate ng ganong klaseng mga products at magbenta ng ganong klaseng product hanggat ikaw yung merong patent para doon sa particular na invention na yun. So, patent owners may also give permission to or license other parties to use their invention on mutually agreed terms. So, if you are the patent owner, you could make terms with others who would like to use your product or would like to reproduce your product by issuing mutually agreed terms with them. No, you can permit them, you can license them, you can issue franchise or license to these people kung saan alam mo magbe-benefit ka, of course. Syempre hindi pwede na mag-i-issue ka na lang basta-basta ng license at pagkakakitaan nila yun nang hindi ka kakita, because that is your invention. Now if you have a patent for it, well, then you can say that, oh, you could use my product, or you could recreate my product, you could manufacture my products, okay, given that you will pay me this particular amount. Pwede ka magpabayad. Okay, pwede kang magpabayad para sa ibinibenta mo na 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 produkto, okay, para dun sa invention na ginawa mo. Okay, is that clear? Okay. So owners may also sell their invention rights to someone else. Pwede mo ring ibenta yung invention right mo. At syempre, pag nabenta mo yun, pagbentahan mo, sila na yung may-ari ng patent na yun. Okay, so very much important if meron kang ginawang panibagong produkto na alam mong very innovative at napakaganda ng gamit sa kasalukuyang panahon, then make sure na i-register mo siya for a patent. Gaano ba kahaba yung tinatagal ng patent, o what is the term of a patent? The term of a patent shall be 20 years from filing date of application. So it will start by the time that you filed or by the date of filing. Okay, the patent right will start from the filing date of your invention, and then it will go until 20 more years. Okay, so for example, you filed your patent January 2020, then you have until January 2040, okay, for that patent. Now, the patent must be maintained yearly starting from the 5th year. Your patent might be cancelled if you reach the 5th year and then you're not maintaining it, or when we say you're not paying for it again and again. Okay? So ibig sabihin, you have 20 years para sa patent ng iyong patent right ng iyong invention. Pero pag dumating na ng ikalimang taon, kailangan mong i-maintain, kailangan mong magbayad o yung proseso every year yung patent na to para ma-enjoy mo talaga yung maximized na taon, which is 20 years para sa yung patent rights. Okay, so pagdating sa patent, no, kung mapapansin natin, mayroong mga produkto na sa panahon ngayon parang pare-parehas na sila. Okay, or marami ng mga kumpanya yung nagpo-produce ng ganong klaseng produkto. Bakit marami ng kumpanya yung nakapag-produce nito? Maaaring nag-expire na yung patent na yung ng produkto na yun. So minsan, if the patent expires, nagiging available siya for public, nagiging parte siya ng public domain. O anyone could make another version of that particular invention of yours kapag nag-expire na yung patent na yun. So ano ba yung application process for the patent? One needs to fill out a request form for a grant of Philippine patent. So meron ding request form, as well as submit descriptions and drawings of the invention or the process. You have to submit yung technical details. You have to submit yung technical functions, okay, descriptions, technical descriptions, drawings, okay, measurements, and if there are calculations, if there are formulas for it, then you would have to submit all of them. So once the application has been filed, it will be published in the IPO Gazette or Intellectual Property Office Gazette. During the period of its application, anyone can write in or contest the application. So during the period of publication, or because it will be made available on the IPO Gazette, I suspect it should be available online so that other people could check on it, or it would be available on the file of the Intellectual Property Office. Then someone else could contest and could tell na, oh, this invention is mine and this is not his or her invention. Meaning, during the period of application, meron ibang tao na pwede nilang i-contest na hindi niya gawa yan, gawa ko yan. Okay? Other people could insist that that invention is there and not yours. Okay, that's why it needed to be published in the IPO Gazette so that it will be made available to those who would like to look at it. So how much would be the corresponding filing fee for the patent application? The corresponding filing fee amount to 3,600 and 1,800 for big and small inventions respectively. So 3,600 for big inventions and 1,800 for small inventions. If you're gonna consider it, maliit lang yan. Maliit lang yung presyo na yan kung kukumpara mo sa maaari mong kitain kapag na-enjoy mo yung patent right ng invention mo. Okay, so that's small compared to the revenue that you could get out from that particular invention because you have the patent right for it. Okay, we're done with patents. So now let's look at trademark. And then I will give you particular cases, okay, Philippine cases for which some company filed for trademark infringement, meaning someone used their trademark for their business. So what is a trademark? If we're going to define a trademark as compared to copyright and patent, trademark is a word, or it could be a group of words, it could be a sign, it could be a symbol, it could be a logo, or a combination of thereof that identifies and differentiates the source of goods or services of one entity from those of others. So ano mga example nito? Mga logo, pangalan, yung mga kataga na ginagamit. So Jollibee has its logo, Jollibee has its brand name, okay? Jollibee has its menu name. Like for example, meron silang yung burger. Yeah, meron silang Jolly Spaghetti. Meron silang Chicken Joy. So these are trademarks. And because Jollibee has applied for trademarks for these particular items or these particular products and services, then other companies should not use these trademarks in their businesses. Because if they did so, then the Jollibee could file a case against these companies. Okay? For another, McDonald's has Big Mac. McDonald's has Cook Float. Okay, so they have these particular trademarks that other companies should not use. Okay, so those are the example of trademarks. Starbucks have Frappuccino and a lot of other products. So they have a logo where there is a mermaid, right? So other companies should not use that logo or imitate that logo and then just tweak something on that logo which would still resemble a Starbucks logo, because if they did so, the Starbucks could file a case against that company or against that business. Okay, so that's trademarks. The fonts being used for the logo, the color combinations of the logo, those are the identifying features of a particular trademarks. Words used, those are trademarks. A trademark protects a business brand identity in the marketplace. Of course, every company, every service, every product should have its identity. Okay? It's something that would separate them from others. It's something that would help consumers to say na, oh, this is the product that I want to use, or this is the product that I give my trust to. Okay? That's the identifying feature. Trademarks are companies' identifying features. And so it's important for companies to register these trademarks, these service marks, so that they will be protected and so that no one would be able to copy their trademarks for the advantage of other companies. Because there are companies who would like to lokohin, kumbaga, yung ibang mga consumers na hindi masyadong nagpipay attention. Okay? For example, diba, there are a lot of brands of shoes. Now, if a consumer does not really pay that much attention on the brand, diba? I mean, on the feature of a particular shoes. Tapos nakita lang nila, oh, parang mukhang Adidas to, di ba? Then binili nila. Tapos pagdating nila sa bahay, nakita nila yung spelling Adidas, ADDI DDAS. Di ba? Double D. Okay? Yung nakalagay dun sa Adidas na yun. So, yun nalaman, napeke siya. Kasi hindi siya masyado nag-pay attention. Ang alam niya lang, ganun yung itsura ng Adidas, pero hindi niya masyadong binasa. So, pinagkakitaan siya at naloko siya for it. Diba? So, ibig sabihin, kailangan maprotektahan yung brand identity talaga ng isang business, no? At talagang ma-separate sila from other businesses. Registration of it gives the owner the exclusive rights to prevent others from using or exploiting the mark in any way. So, ibig sabihin, if a particular company has an exclusive right on that particular trademark or service mark, they could stop others from using, number one, and for another, from exploiting the mark. Ba? I mean, if someone would use McDonald's, then they're just gonna flip M, then they'll make it W, then they're exploiting that mark. Ba? Or someone would use the name Jollibee and then tweak the word Jollibee and make it Jolly A or what? I mean, at ma-identify mo rin, ma-identify mo pa rin siya from sa Jollibee, then they're exploiting the mark. Ibig sabihin, tinitweak nila yung mark at gumagawa sila ng copy na hindi naman ganun kaganda, pero pwede nilang pagkakitaan kasi makukuha nun yung attention nila. Right? So, aside from being a source identifier, differentiator, quality indicator, an advertising device, a protective mark may also bring another stream of income to the owner through licensing or franchising. Of course, if you have the rights to this, you could allow someone else to franchise your business, no? Sa China nga, 'di ba? Merong mga nakapag-spot ng fake na Jollibee, nakalagay Joy Rulby. 'Di ba? Joy Rulby. Diba? At marami pang mga iba. So, yung ibang mga maliliit na businesses, medyo hindi naman na sinisilip ng mga malalaking businesses kapag medyo ginagamit at exploit nila yung mark. Pero kapag yung mga maliliit na businesses na yun, lumaki na. At kapansin-pansin na, grabe na yung kita na nangyayari din sa mga businesses na to dahil ginagamit nila or in-exploit nila yung mark natin, then that's the time na nagpa-file na ng case itong mga malalaking companies na to. A trademark can be protected in perpetuity if regularly monitored and properly maintained. Ibig sabihin, ang isang trademark pwede siyang magpatuloy sa habang panahon o sa tagal ng panahon. At wala siya talagang particular na hanggang 20 years lang yan, hanggang 5 years lang yan, hanggang 10 years lang yan. Given na dapat it's being regularly monitored and properly maintained. Okay, ibig sabihin, may laging minomonitor, laging nagbabayad ng rights, ng trademarks rights for it. Kasi, lalo na kung mga businesses yan, di ba yung mga businesses, pag naman namatay yung original owner, pinapasa nila sa mga anak nila. So, yung mga anak nila, sila na magpapatuloy ng businesses. Kaya, ang gagawin ng mga to, ikikip nila yung mga trademarks na talagang kung saan kumita na at nakilala ang kanilang mga businesses. Okay? The period of protection is 10 years from the date of issuance, and is renewable for a period of another 10 years. So 10 years at a time. Okay? If you register the trademark this 2020, so you have up until 2030. Yan. Then after 2030, mag-a-apply ka ulit ng panibagong 10 years. Okay, na protection ulit para sa trademark na yon. So extend mo siya for another 10 years. Then after 10 years, extend mo na naman siya for another 10 years and so on and so forth. Okay? So, 10 years yung validity. Kaya kailangan, every 10 years, nagbabayad ka ulit. Every 10 years, talagang mini-maintain mo yung trademarks na meron ka. Application process, similar to patent. I-apply mo yung, or i-file mo yung exclusive rights for the mark you wish to use for business purposes. As the rights to a mark are granted to the first person who filed the IPO, it is imperative that the one would conduct a search within the IPO's database to avoid redundancies in application. So, bago mo siya ma-file ng maayos, kailangan mo muna mag-search dun sa IPO database kung meron na bang kaparehas na mark, kaparehas na trademark, kaparehas na service mark yung i-apply mo. Okay? Kasi kung meron na, hindi i-allow ng IPO na may apply mo yan for another one, for another right. Kasi kung may kaparehas yan, automatically, hindi yan papayagan. Okay? Hindi yan papayagan ng, ng IPO na may apply mo. For filing purposes, one needs to fill out the trademark application form, attach the drawing of the mark or the description of the mark. Then you have to file the corresponding fees amounting to 2,160 and 1,080 for big and small marks. So 2,160 for big trademarks and service marks, then 1,080 for small marks. What is the penalty for the infringement? So if someone copied the mark or exploited the mark, the penalties range from 50,000 pesos to 200,000 pesos and or 2 to 5 years of imprisonment. Okay? So that is what our law is saying, na magiging parusa for someone na nangopya. Okay? So let's look at a particular instance. Del Monte, Del Monte is an international company, pero dito sa Philippines meron silang manufacturer o meron silang ina-allow na mag-manufacture ng kanilang mga products. Then we have a Sunshine Sauce. Sunshine Sauce is a Philippine company na nagpo-produce din ng iba't ibang mga sauce. Okay? At there was a time na ang Del Monte, kinasuhan nila itong Sunshine Sauce for infringement of trademark and unfair competition. Ano bang ginawa ng Sunshine Sauce? So, ang Sunshine Sauce ay isang local corporation at distributor at manufacturer dito sa Philippines. They were found guilty of infringement dahil gumamit sila ng recycled Del Monte bottles para sa kanilang mga produkto. Okay, gets natin, recycled, that's good, diba? It's good for the environment. Gumamit sila ng recycled. Ang problema, diba, kadalasan yung mga Del Monte bottles, sa mga bote ng Del Monte ay kitang-kita kadalasan yung kanilang logo. Diba? Kasi yung mga bote ng Del Monte, hindi lang sticker yung kinakabit nila para sa logo nila. Doon mismo sa bote, nakatatak. Doon mismo sa bote nila, what do you call this? Nakatatak o nandun mismo, okay? Nandun mismo yung logo nila sa bote nila. Nakaukit. Yun, that's the term. Nakaukit mismo sa bottle nila, yung logo nila. Okay? So, yun yung pagkakamali ng Sunshine Sauce. Okay? Recycled nga, kaso yung mga Del Monte bottles, nakaukit mismo yung logo. So, ngayon, nagkaso yung Del Monte. Kasi, sabi nila, medyo unfair competition to kasi kung merong isang buyer na hindi siya masyado nagpe-pay attention, nakita niya lang yung bote na merong nakaukit na Del Monte logo doon. Kaya niya, ito yung binibili kong produkto, di ba? Pwede niyang kunin yun, tapos pag uwi niya sa bahay, pag tingin niya, hindi pala ito Del Monte. Sunshine Sauce pala to. Okay, na nakalagay lang sa bote ng Del Monte. Okay? So, kinasuhan sila ng Del Monte, itong Sunshine Sauce, at may panalo na Del Monte yung kaso. Sapagkat Sunshine Sauce was found guilty of infringement of trademark and of the unfair competition. Another example, Starbucks. So, merong isang Filipino company na Cafe de Manila Corporation na sinubukang gamitin yung frap para sa kanilang marketing slogan, yung term na frap. Yung Starbucks, meron silang trademark right doon sa salitang frappuccino, which is something that they offer talaga, di ba? So, di ba, ito yung pinakasikat na produkto ng Starbucks na masasabi natin. When we go to Starbucks, we ordered frap. Di ba? So, yung Cafe de Manila Corporation, sa kanilang marketing slogan, sabi nila sa isang phrase nila, the frap bar everyone deserves and designs. Yun yung kanilang marketing slogan. So, nasilip to ng Starbucks, nakita to ng Starbucks. Kaya naman, they filed the case na Cafe de Manila Corporation has no right to use frap because it's registered under us. We have the trademark for it. Okay, so Starbucks won. Kaya hindi nagamit ng Cafe de Manila yung salitang frap. Okay, is that clear? So, yeah, so far, ano ng mga na-discuss natin? Copyright. Copyright is for your original work. It could be literary and artistic or scientific work. And ang copyright from the time that you've created that work, meron ka ng copyright dun, even if hindi mo siya na-register. And then we have patent. Patent naman, it's government issued na right, so kailangan talaga siya i-register. Ito yung para sa mga bagong inventions, mga new and innovative products, meron kang bagong in-offer sa market na produkto, so i-register mo siya under a patent. Then pangatlo, dinascuss naman natin yung trademarks and service marks. Ito naman yung mga ginagamit ng mga businesses bilang kanilang brand identity. Okay? Or anything na nagpapakita ng kanilang identity at nagsiseparate sa kanila from other companies and from other products available in the market. So, companies should also apply for a trademark. Then, pangatlo, we have industrial design. So, industrial design, most likely kadikit siya ng patent. Okay? Pero, ang industrial design kasi is concerned on the ornamental or aesthetic aspect of a invention or an article. So, from the word itself, design, so naka-focus siya dun sa disenyo, dun sa itsura, sa size, sa design patterns ng isang particular na object. Pag patent kasi kadalasan bago siya, innovative siya. So kapag ang patent, in-apply mo siya for patent, you have to make sure na it's something new. It offers a new bagong use sa market at sa consumers. Pero pagdating sa industrial design, dun lang siya sa design. Dun lang siya sa itsura, sa kulay. Okay? So you can apply for industrial design for the products that you're offering in the market. So design in the sense that three-dimensional features of the design, the shape, the surface, no? Yung surface, yung size ng iyong produkto. It could also be two-dimensional features, mga patterns, lines of color, okay, designs, okay? So, ilan sa mga pwede mong i-apply for industrial design is yung mga itsura, disenyo ng mga handicraft na meron ka, itsura ng yung mga jewelries, okay? Yung mga patterns, color designs, shapes ng jewelry na meron ka, vehicles also, appliances also. So, parte yan ng mga industrial designs. So, it ranges from fashion to industrial goods. The owner of a registered industrial design has the right to prevent third parties from making, selling, or importing articles bearing or embodying a design which is a copy or substantially a copy of the protected design when such acts are undertaken for commercial purposes. So if you own industrial design rights of a particular design, okay, then ibig sabihin meron kang karapatan na pagbawalan ng iba na gamitin yung design na yon at gamitin yung ganong klaseng patterns, color combinations, okay, or 3D design ng iyong produkto. Okay? Registration for industrial design is for a period of 5 years from the filing date of the application. The registration of industrial design may be renewed for not more than 2 consecutive periods of 5 years. Okay, each by paying a renewal fee. So, unlike other rights, medyo mas maliit lamang, no, mas mababa lamang yung years of protection na may enjoy mo for applying for industrial design rights. Okay, 5 years lang siya from the filing date of the application. Pwede mo siya i-renew ng isa pang 5 years, pero hindi na pwedeng sumobra doon. Kaya kung makikita natin minsan yung mga, kunyari, designs ng mga fashion, jewelries, yung ibang companies after some time, ginagawa na rin nila yung ganong klaseng design. Okay, or design ng mga cellphone. Diba? There was a time na Apple lang yung may ganong klaseng itsura. No? Or Samsung lang may ganong klaseng itsura. Pero after some time, na nawala na yung industrial design ng company na yun for it, free na rin yung ibang mga companies to do it. Kasi, wala ka naman ng industrial design right for it. Industrial design right protects only the appearance or the aesthetic feature of a product. Okay, as compared sa patent. Sa patent kasi, ang pinoproteksyonan ng patent, kaya ka nag-a-apply ng patent kasi gusto mong maproteksyonan yung technical and functional features. Okay, yung mga technical details. Okay, yung mga functional details. Okay, ano bang gamit nito? Para saan ba to? Paano ba to gagawin? Okay? Kung may mga formula dyan, may mga calculations dyan, yan yung mga under noong patent right. Pero kapag industrial design, appearance lang, yung itsura, yung aesthetic, yung mga design, yung patterns, yung size, yung color combination, yun lang yung under ng industrial design. Pero kapag patent, yung technical and functional features of a product, yun yung kinocover niya. Okay. So, example, bigay na ng example ng isang infringement case for a industrial design. So, Nike, nag-file siya ng kaso against Skechers dahil in-infringe daw ng Skechers yung 8 design patents ng yung design patents ng Nike na sapatos. Okay? So Nike filed suit against Skechers USA on 2016 in the United States District Court for the District of Oregon, Portland Division, seeking to recover damages and costs from Skechers. In the complaint, Nike alleges, sinasabi ng Nike na yung Skechers daw infringes 8 Nike design patents issued between January 2014 and March 2015. Okay, pertaining to shoe uppers and shoe soles. So, ang ginaya daw is yung itsura ng pangitaas ng mga sapatos na to at maging yung sole, ba yung talampakan na design, itong mga design ng Nike. So, tingnan natin ano ba itong mga to. So, ito yung example. So, ito yung patent figures. Okay, so ito yung patent figures ng Nike. Sinasabi nila na ginaya daw yung sole. Diba? Yung itsura ng sole. Ginaya daw to ng Skechers. Makikita natin, malaki nga talaga no, yung pagkakaparehas. Okay? So, kita natin yung design, yung pattern. Diba? Kumpara natin sa Nike. Diba? It's the same. Diba? Yung gilid, yung likod, it was the same. Okay? Tingnan naman natin yung design. Yan, yung neat. Di ba? Yung marami tayong mga neat o K-N-I-T. Okay, na design ngayon. Kita natin, ito yung patent. Ito yung industrial design rights na ini-apply ng Nike. Makita natin Skechers. May pagkakatulad nga. Okay? Also yung pagkakakulay. Okay? So, may pagkakatulad nga talaga naman. So, yun daw yung ilan sa mga designs na kinopya ng Skechers. Kaya ang Nike ay nag-file ng lawsuit against Skechers for copying their designs. Okay. So, now, ito yung mga nakasulat sa IP code. Again, copyright, patent, trademarks, and industrial design. Ngayon, saan papasok yung plagiarism? Actually, sa IP Code of the Philippines kasi walang plagiarism talaga na binanggit, no? Pero ang plagiarism papasok siya sa isa sa mga diniscuss natin kanina. Okay, so saan? Yun yung alamin natin. Plagiarism is defined as the act of appropriating ideas of another and presenting them as one's own. Ito po yung nangyayari kapag ikaw, kinopya mo yung gawa ng iba at sinasabi mong sa yun. No, sa klase, sa mga eskwelahan, yan, usong-uso to na ginagawa ng mga estudyante. Copy-paste na lang, di ba? Kasi papasa nila, under their name, walang proper citation, kinopya yung buong paragraph, kinopya yung buong sentences, na wala man lang proper citation. Okay? Hindi man, walang rephrasing and proper citation na ginawa. Okay, that's plagiarism because sinasabi nyo na sa inyo yung idea na yun, pero hindi naman sa inyo talaga yun. Okay. It is considered as a crime. Okay. Tandaan natin, I will give emphasis to this, plagiarism is considered as a crime if done against provisions provided by the Intellectual Property Code, the E-Commerce Act, or the newly enacted Cybercrime Prevention Act. So, hindi lang po pumapasok yung kaso ng plagiarism sa iisang batas, kundi naka-integrate po ito sa 3 batas na meron tayo sa Pilipinas. So, madidiscuss to sa Intellectual Property Code, which is yung pinag-aaralan natin ngayon. Pasok din to sa E-Commerce Act at pasok din to dun sa Cybercrime Prevention Act. So, 3 batas po yung maaaring mag-cover itong sinasabi nating plagiarism. So, under the IPC or Intellectual Property Code of the Philippines, yung dinidiscuss po natin ngayon, the act of plagiarism ay pumapasok po doon sa copyright infringement o doon sa paglabag sa copyright ng iba. Because pagdating sa usapin ng copyright, it is about original works of literary and artistic nature and scientific nature. So, pasok po sa copyright infringement yung plagiarism. Ibig sabihin, maaari kang makulong ng 3 to 6 years at maaari kang pagbayaran ng 50,000 to 150,000 pesos kapag napatunayan na lumabag ka dito sa batas na ito. Okay? Now, sir, cover po ba dyan kapag nag-plagiarize po tapos ipinasa bilang isang educational requirement sa klase? Makukulong po ba ako? Ang sagot hindi. Pero masizero ka automatically doon sa activity na yun. Kundi naman, pwede kang ibagsak ng teacher mo. Depende, of course, sa rule na meron tayo sa eskwelahan. Okay? Now, kapag ikaw naman, ginamit mo to for commercial purposes, pinagkakitaan mo yung gawa ng iba, then that's the time na makakasuhan ka at pwede ka makulong ng 3 to 6 years at pwede ka magbayad ng 50,000 to 150,000 pesos. Okay, so I hope that's clear with us. Sana let's not commit act of plagiarism, lalo na pagdating nyo sa college. Okay, so ngayon pa lang ay pinapractice na tayo na let's not commit act of plagiarism. Now, let's go to our activity. For our activity, yan, this will be a group research. Everyone in the group will have to do a research. Ano po yung group natin? Yung group po natin is yung group na meron tayo for the docu. Okay? Yung docu po, isang tabi na lang po muna natin yan. Okay? Pero gagamitin po natin yung group na meron tayo sa docu para dito po sa group activities na meron tayo for the online classes. Again, yung grupo po natin is yung nabuo nating grupo doon sa ating documentaries. Activity. Research on the case study about plagiarism issues by high-profile Filipino personalities and by government offices in the Philippines. So each group will be assigned with a particular case study. Okay? With a particular case study. You have to make a PowerPoint presentation for the report, and you would have to tackle the following things sa inyong report. Tackle how they committed plagiarism. Ano yung ginawa nila? Bakit sinabing plagiarize to? Discuss how the person or the group addressed the issue. Ano sinabi nila patungkol dun sa sinasabing sila yung nag-commit ng plagiarism? Discuss the reaction of the public. Ano naman sinasabi ng publiko? Ano sinasabi ng netizen patungkol dun sa ginawa nila? Pangapat, i-discuss natin kung may nagkaso ba sa kanila o meron bang nag-file ng lawsuit sa kanila for their so-called plagiarism. Okay, so let's discuss kung ano yung mga issues na ibibigay sa inyo. Okay, then the third thing na kailangan natin gawin ay kailangan natin i-record in a video. Pwedeng katulad ng ginagawa ko ngayon na hindi naman kailangan nakikita yung mukha nyo. At ini-screen record nyo lang yung report nyo at may nagsasalita lang at napapakinggan ko lang kung sino man yun. Para hindi na kayo magkita-kita pa, pwedeng ilimit nyo sa dalawa or kahit isa na lang yung magre-report. Okay? Provided na lahat ng member ng grupo, meron man lang na itulong. Merong na research, merong opinion na sinabi, okay? At merong contribution ng lahat. Now, kapag walang contribution yung grupo nyo na yan, huwag nyo isusulat sa papel. Huwag nyo isusulat doon sa video. Okay? Or huwag nyo ilalagay sa mga tumulong para doon sa video. Okay? So, next, the report, the video should be 5 to 10 minutes long. Okay, 5 to 10 minutes long. 5 to 10 minutes long lang dapat yung video na gagawin nyo. Make sure it's audible, napapakinggan siya na naiintindihan siya, naunawaan siya. Okay? So, ito po yung mga case studies natin. Paano po natin to hatiin? So, nahatiin natin. Okay. Para sa group nila Bacalya, Araya, Angeles, Manukay, Bacalya, Araya, Angeles, Manukay, and so on. Sa inyo po yung orange and lemons, big hit. Para sa grupo nila Valencia, Susa, Abalos, Castillo, Gonzaga, and so on. Para sa grupo ni Valencia, Susa, Abalos, Castillo, Gonzaga, and so on. Sa inyo naman yung Associate Justice Mariano del Castillo's rehashed decision. Okay? Research on it. Para sa grupo ni Manuel Pangilinan's para sa grupo na magdidiscuss ng Manuel Pangilinan second-hand spills, sila ay sina Pablo, Dionisio, Kai, Sanchez, Petras, and so on. Again, Pablo, Dionisio, Kai, Sanchez, Petras sa inyo yung Manuel Pangilinan's second-hand spills. Para naman sa grupo nila Peñafiel, Gasic, Garcia, Santa Maria, Molay, etc. Para sa grupo nila Peñafiel, Gasic, Garcia, Santa Maria, Molay, etc. Sa inyo naman yung Pilipinas kay ganda logo, and it's more fun in the Philippines slogan issue. Okay, sa inyo yung number 4. Para sa grupo nila Vigarano, Narag, Marcos, Suarez, Santos, and so on. Para sa grupo nila Vigarano, Narag, Marcos, Suarez, Santos, so on. Sa inyo yung Senator Tito Soto's plagiarism issues. Senator Tito Soto's plagiarism issues. Okay? So, yan yung para sa Esther. Thank you, Esther. Punta tayo sa Nehemiah. Nehemiah, ito naman yung mga i-discuss nyo. Para sa grupo nila Rosete, Villaverde, Pasiola, Gacer, Juanes. Para sa grupo nila Rosete, Villaverde, Pasiola, Gacer, Juanes. Number 1 yung sa inyo, Orange and Lemons, big hit. Number 1, Orange and Lemons, big hit. Para sa grupo nila Sagkal, Araya, Arce, Viador, Simon. Number 2, yung sa inyo. Para sa grupo ni Sagkal, Araya, Arce, Viador, Simon. Number 2 yung sa inyo, Associate Justice Mariano del Castillo's rehashed decision. Para sa grupo nila Tandog, Sandaga, Riel, Dalumpines, Molay. Grupo nila Tandog, Sandaga, Riel, Dalumpines, Molay, and etc. Sa inyo naman yung Manuel Pangilinan second-hand spills motion. Number 3. Manuel Pangilinan second-hand spills. Grupo nila Villanueva, Susalta, Laberinto, Lobitos, Javien, etc. Villanueva, Susalta, Laberinto, Lobitos, Javien, etc. Sa inyo naman yung Pilipinas kay ganda logo, and it's more fun in the Philippines slogan. Para sa grupo nila Aurino, Bacanto, Dacuan, Mendoza, Parafina. Para sa grupo nila Aurino, Bacanto, Dacuan, Mendoza, Parafina. Sa inyo naman ay Senator Tito Soto's plagiarism issues. Okay? Mind you guys, this is for 100 points. Okay? Malaki yung mawawala sa inyo kapag hindi nyo ginawa ito at kapag hindi kayo tumulong sa inyong groupmates. Gusto natin makagraduate, di ba? So, sana makatulong tayo sa ating mga groupmates. So, ito yung criteria. Ito yung grading rubric na gagamitin natin. Outline and report organization, 20 points. Clarity of presentation, for the communication skills, 20 points. Clarity of presentation, knowledge of the issue, it's 30 points. Application of lesson concepts, it's 20 points. And then length of presentation, kapag sumunod tayo sa format na 5 to 10 lamang, it's 10 points. Okay? So, I hope it's clear with you guys. Magamit sana natin yung mga napag-aralan natin dito doon sa pag-discuss natin ng case study na naka-assign para sa atin. Research, make a PowerPoint, record it, 5 to 10 minutes long of the video, make sure maririnig siya. Then, these are the case studies. And this is the grading rubric. That's it. Again, God bless you. Stay safe. Palakasin ang resistensya. Iwasin mo ng public places. Lagi magdasal. Okay? At mag-aral pa rin. Lamang, see you again sa mga susunod na online classes.